and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. In a recent statement, Minister of Law and Institutional Reform, Azalina Othman revealed that Malaysia still has some 3,000 archaic and obsolete laws on the books, many of which are no longer serving a meaningful purpose. Now, can we afford to leave these legal relics untouched, or does their continued existence risk undermining the needs and values of contemporary Malaysia? Well, joining me on the show to discuss this further is Professor Jason Chuah, who's the Dean of Universiti Malaya's Faculty of Law. Professor, thank you so much for being on the show with me. It's good to have you here to discuss this. When we talk about outdated laws, maybe the term that we often hear is archaic and outdated and obsolete, but I think clarity in language is so important. So how would you define what is archaic and obsolete in our legal system?
Yeah. Salam sejahtera, and thanks for having me, Melissa. I think it's really, you really hit the nail on its head. I think it's terribly important for us to understand exactly what we're talking about. To me, this perhaps is the beauty of the English language, isn't it? Because when we talk about something that's obsolete, it could tell us that it is something that is very old and very ancient. It could also tell us that it is something that is irrelevant for what we are experiencing in our societies today. It could also tell us that it may be unsuitable because it's been overtaken by modern developments and so on. So I think the word itself is very critical. And when we are thinking about the laws that could be considered obsolete, I think this is where we need to be quite careful, because a knee-jerk reaction, a knee-jerk response is not going to be helpful. So for example, if we lump all our old laws together, assuming that they're all bad, then suddenly we're daunted by the tremendous task of having to set up structures and procedures and processes to try to ameliorate all these problems. And I think that is a bit, well, if you pardon my saying so, a little bit crazy, despite the noble ambitions. So I think that's quite important. So to me, that's the first thing we need to think about. So let's not lump them all together. We need to have a particular process whereby we can delineate between the types of laws that we really have got a problem with.
Okay. All right. So talk to me. I love that you wrote an op-ed about this, about obsolete laws, and you said that you've picked up this hobby of collecting old and archaic laws. What kind of laws would you consider obsolete in today's legal system for Malaysia?
I think as far as I'm concerned, if we are looking at this as a matter of policy, then obsolete and irrelevant is one thing. Obsolete and objectionable is another thing. Obsolete but harmless is the third thing. So to me, I have been looking at a lot of old laws, mainly because I'm very interested in legal history and legal language, especially in Malaysia. And as a result, I've picked up a lot of different old laws and statutes and enactments, some going back to the Federated Malay States, the Strait Settlements, and so on and so forth. And you could basically class them into three groups. Obsolete, but perhaps, irrelevant; obsolete but objectionable; obsolete but harmless. And what should be our priority? And to me, if we are looking at this as a matter of policy change or policy decision taking, our priority should be those laws which are out of date but objectionable. I'll give you an example.
Okay.
So we have a law in the Evidence Act which says that a boy shall be presumed to be incapable of committing rape. Now that, of course, is quite arbitrary if you think about it. Because why should a boy, simply because of his age, be presumed to be incapable of committing rape? The science doesn't back that up. We know that young boys indeed can have sexual relationships, for example. So we know, therefore, that such a piece of legislation is perhaps, to my mind at least, objectionable. And should, of course, the priority therefore be to change that. Another one might be to say that, so we've got a piece of legislation which says that children, of course, would not be subject to the death penalty, but they would be subject to indefinite imprisonment. Now, indefinite imprisonment with no process for review or to reassess or to look at whether the child has been rehabilitated, to me that's objectionable as well. So there are, to me, these laws which are old but objectionable. But then there are also laws which are old but quite harmless.
So that's interesting. What is the difference, the nuances between obsolete and irrelevant and obsolete and harmless?
Okay, I'll give you an example. Obsolete but harmless might be the gold mining, a gold buyer's enactment. Okay, never heard of it.
Never heard
fine.
of it,
That's
yeah.
fine. That's absolutely fine. So back in the day, when private individuals wanted to sell the gold that they have mined, now you've got to try and remember back in the day, we're talking about, sort of turn of, I was going to say turn of the century, but turn of the last century.
The last century.
And you will remember that people used to take their little dulangs or the trays, and they would go and basically sieve for gold or tin or whatever, all right? And in order for you to be able to carry this dulang into this mining area, the colonial officers would have got to issue you with a license. Now that license is called dulang pass. Now the law still remains that if you do not have a dulang pass, you cannot sell the gold that you have discovered using your dulang. So now,
how many of us still use the dulang to search for gold?
but why should we want to set aside parliamentary time to do anything about this?
Okay.
To me, it is old, but not, it's harmless.
Harmless. Are there laws that you think are obsolete and irrelevant and deserving of our attention for reform?
So I think this is if you like, if there's a gradation, at the top of the scale has to be those which are objectionable. And then at the lowest rung, you have those which are pretty harmless. And then you've got the middle ones. So the middle ones are those which have largely been taken over by technology. So for example, you have laws dealing with auction sales. And these are very old laws and pre-independence laws. And they pretty much say that, well, you have to have X number of people in the room before you can be said to have the right to conduct a proper auction, for example. But now people do auctions online. They don't need to go and sit in, a little hotel seminar room just to bid. They don't bring those placards to auctions. So that environment has totally changed. But, well, it is a piece of old law, to my mind, which is irrelevant and should be changed, but it's not at the top of my list of priority.
Right. So you have noted 4 possible outcomes for outdated laws in the categories that you talked about. You've mentioned revision, repeal, reform, or doing nothing. How do we sift through and put those in the categories that need doing something, need revision, need reform, need repeal, or just be left alone?
So in Malaysia, we have a legal distinction actually made between law revision and law repeal. Okay. So to repeal usually comes also with amendments, and of course it may come with reform, which means that you cancel out the old law and you introduce new law, or you play with the old law and you amend the old law. Revision, on the other hand, is you keep the old law, but you modernize the structure and you modernize the language. Now, to me, law revision is actually very important, but it is also a supremely impossible task, because the challenge is that, and you raised something which I thought was very apposite right from the outset, and that is language. Because if we, and definition, because although a word is used might sound rather obsolete and we would like to change and modernize that, the minute we do so, we also change the legislative intent, don't we?
Okay.
So let me give you an example.
Yes.
So let's say we don't like a particular phraseology, such as, be that as it may.
Is that in some
Yes.
legal?
Well,
Okay, that's a legal phrasing.
Okay,
Okay.
let's just use that as an example. Be that as it may. Now, if you think of an alternative, that alternative may not be as relevant and it may not be as powerful in conveying the message that regardless of this, we will go forward with that. That is what be that as it may means. So when you have got phrases which sound rather old and you want to modernize them, you may not be able to do so. And this, of course, comes in the form very powerfully in some of our very, very entrenched and important legislation, such as the Penal Code or the Contracts Act. Now, these are laws that basically everyone has to live by because they guide our everyday lives. But if you look at these laws, they use very particular words, like, for example, A concerts with B to do da-da-da-da-da. Now, if you are a linguist, you look at the word concert and it connotes certain sort of imagery. But then concerting is a very old word. I do not talk about concerting with my friends. I do not talk about concerting with my colleagues. Concerting, of course, means that you are coming together and you have worked through something and you agree to doing something and you conspire to do something. That is concerting.
Right.
But the word concert we don't use anymore. But try to replace it in the law. Just as part of your law revision exercise, you change it. Let's say, what would you change it to? If you change it to, conspire, you've changed the connotation because conspire sounds rather bad,
There is
doesn't it?
a negative
Yes.
malice
Absolutely.
connotation to it.
That's
Okay.
correct. So you therefore keep the word concert, but ordinary people reading the legislation have not seen the word concerting except in, a pop concert. They would not understand what that means.
Okay, so when we think about how sensitive the process is and how complex the process is for revision of law, how do we deal with the objectionable obsolete laws? What needs to be done? Is reform the other option?
So with those laws which are objectionable, then we have to engage parliamentary process because those laws need to be repealed and they need to be changed. And of course, there's only one way of doing it properly, and that is through Parliament. So those, I think, to me, the critical element there is not the process. The process is actually very clear.
Okay.
The critical element there is trying to ascertain what we mean by laws which are objectionable. Sometimes, they're pretty obvious, like the ones I've given you, but others may not be so obvious because, our values and our norms are all not always, the same with each other.
And sometimes the values of society and maybe of government could be different. So when we think about archaic laws, or laws that have been labeled archaic in public domain, I think of laws like the Sedition Act, like the Printing Presses Act, that are objectionable to some people, but may not be as objectionable to the people in power. So how do we think about that? That are there certain laws that are obsolete and objectionable that have a place in society and in governance?
Well, to me, then, you have to really go back to how do we measure something as objectionable. In law, number one, you can measure that by looking at our federal constitution. So a law which goes against the constitution, for example, you talk about printing presses, sedition laws, and so on. if we have come to a point in our jurisprudence of constitutional law whereby we recognize a certain height of freedom of expression, then you could say, okay, this piece of legislation is objectionable and should really be done with. So that's one measure. The second measure, of course, is, to me, looking at international standards and international norms. So we have got international conventions that we may not have signed up to as a state, but nevertheless, they tell us something about where humankind is moving towards. You know, what are we actually concerned about? For example, you know, what do we mean when we talk about right to family life? Now, right to family life is not in the Constitution. However, increasingly we're beginning to see that the right to family life is an important norm, if not an important right. And so if we see that as the case, and any laws which seem to go against that, then perhaps we should do something about. But this is where Parliament is very important, because in Parliament, these issues get debated, they get, you know, sort of spoken about, and stakeholders and, you know, the interested civic societies will all then jump on board, and they will want to have their views heard and aired. And so as a result, we find that because we live in a democracy, and we're very fortunate to be in a democracy, we find that there is this process of dealing with objectionable laws.
In a Malaysian context, with all the constraints that we have with the kind of institutional, bearing in mind the institutional strengths and the limitations of Parliament sittings, right? We don't sit very often. We have a lot of things to discuss in Parliament, and often legislative priorities get muddled. So when we think about how to address this, given the constraints of Malaysia, how do we prioritize which objectionable laws to look at?
That is a beauteous question, Melisa, if I should say so. It's really looking at what we should do, isn't it? So parliamentary time being a constraint, parliamentary resources being a constraint, these are realities. Every country faces these challenges, but it's how we resolve them. So to me, because parliamentary resource and time are so precious, that we need to prioritize what we want to change in terms of old laws. I think, you know, sometimes I like to think of sometimes people get very vexed and very upset and annoyed about old laws, because they say, oh, this is so, you know, sort of, it doesn't tell us anything about our current society, you know, it's so colonial and so on. It's all part of a decolonization issue. I understand that. There's strength of feeling in that, you know, that people are passionate about why do we want to keep all these old straight settlements laws, you know. But on the other hand, if parliamentary time and resource are so limited, then from a practical point of view, should you really do very much about them, first of all, you know? And then secondly, I think that there are two other possible solutions. One solution, of course, is to institute and establish in Malaysia what a number of jurisdictions have already done so, and that is to have a law reform or a law reform commission or a law reform committee. Now, this body should be as best as possible neutral, and they then get to set what the agenda of law reform should be. They then get to be tasked with the onerous burden, but it's also a deep responsibility, but also an honorable responsibility of identifying those laws which we have talked about, the laws which are irrelevant and the laws which are objectionable, and look at how we can change them to make our legal framework and our legal environment much more pleasant. So that's number one. Number two, when it comes to laws which are irrelevant but are not, perhaps not doing very much harm at the moment, we can allow for these laws to be tested in the courts. So I'll give you an example. In the United Kingdom, there is a piece of legislation called the Human Rights Act. Under the Human Rights Act, a court, when faced with a particular piece of legislation, is entitled to ask whether this piece of legislation is in conformity with the human rights principles established in the Human Rights Act. Now, if they think that this piece of legislation may not be, then what they could do is to make a reference back to Parliament and say, you should do something about this because we have identified a problem for you.
Okay.
But you see, you wait until the problem appears in court, which means that you're not having to go into the archives and digging up all, you know, these very old laws.
So using the courts as maybe a litmus test as to which laws need to be debated. So empowering courts.
That's correct.
To decide
That's
which
correct.
laws or deserve parliamentary attention.
That's correct.
Okay.
That's correct. So so the courts do not take over. They do not usurp the power of Parliament, but they have a responsibility to inform Parliament that we feel that this piece of law is actually irrelevant. Do have a look at it.
Is that realistic for a Malaysian setting? Could it be done?
Well, I don't think why it could not be done, because at the moment Malaysia, as you know, is a country governed by constitutional supremacy, which means that the courts are already empowered to say that a piece of law is inconsistent with the federal constitution. And in fact, it gives our courts the power to strike a piece of legislation down on that very basis. But we're not going that far because we're simply talking about obsolete or archaic laws. So it's not for the courts to change the law, but it's for the courts to say, actually, look, you know, this auction law talks about sitting in a room and counting heads. Why should we do that? So perhaps Parliament might want to take that up. So little by little, we then get to address, if you like, working in tandem with, of course, the Law Reform Committee or Law Reform Commission's work.
So we have the Minister, Azalina Othman, who has already said that, you know, we've got this many number of laws that needs our attention. What would you like government and her ministry or her team to prioritize when considering which laws, which obsolete laws require time and attention to either revise or repeal or reform and the like?
Well, first of all, I think that whether there are actually 3,000 pieces of
that was the number that's been...
Yeah, that's the number that's been bandied around.
Do you think it's an overestimation or an underestimation?
I think it depends on what one means by archaic laws. So if you're looking at pre-1969 laws, and why 69 is important is because the Revision of Laws Act was passed in 1968, and the process of revising old laws then began. Revising is not repeal, revising. And that means that there are older legislation before 1969 which had not been revised, but you know they're sort of gradually being looked at and so on. So pre-69 laws, of course, there are one thing, but the law revision work which is undertaken at the moment by the Attorney General's office is actually making very good progress. So I think that in a sense, if you get down to it, I would say about 200 something pieces have not really been dealt with. So the number comes down considerably. But of course, it depends on what you mean by archaic. It always goes back to that. And so to me, that is why it's so, why I feel so gratified that that was the first question you put to us, and that is about definitions. Because definitions are very important, and if we know what we're talking about, that gives us a great deal of clarity of thought. And of course, once you get clarity of thought, then you can map out the progress to get to where you want to get to.
Well, thank you so much for shedding light on such an interesting topic and not one that is often discussed on the show. So thank you for your time and for your insights. It's been a pleasure.
Thank you so much. Thank you for having me.
That's all we have for you on this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching, and good night.